Court. And today we will be discussing the case of Crown against R, 1991. The British landmark case that at last acknowledged the fact that marital rape ought to be punished, creating immense changes for women's rights in not only the British justice system, but also leaving a memorable precedent for other justice systems across the world.
Today's drink is our homemade strawberry jam, matcha and espresso.
Yay!
Taste test!
Before we move further on to the case and analysing it, I just want to quickly talk about how we read the case name. So you might be thinking, why did I just say Crown against R when it's literally written as RVR? So basically the reason for this is that it's just a Commonwealth thing where we read case names differently from how it's written. So in this case, the first R of RVR actually means crown, and the V in the case name is actually said as against, unlike the American system where they say versus. And then the second R is just kind of an anonymous label thing for the perpetrator in this case.
Okay, so let's move on to the taste. In August 1984 England, two anonymous people were a married couple and had a son together. On the 21st of October 1989, the wife left their house with their son to live with her parents, after leaving a letter behind for a husband, indicating her desire to get a divorce.
Then on the 23rd of October 1989, the husband spoke with the wife via call, also communicating his intent to get a divorce. But after this conversation had taken place, no other formal procedures were carried out for their divorce, hence they were still legally married on the papers but were practically separated.
The following month, on the 12th of November, the husband broke into the wife's parents' house and violently attempted to rape her, assaulting her in the process by grabbing and pressing on her neck.
Well, remember how I just mentioned the two were still legally married?
Yeah, so that meant that in the process of trying to prosecute the husband, there were conflicts with previous and long-standing concepts in the law that a husband cannot be guilty of raping his lawful wife.
And this idea was very much viewed as a standard at the time, mainly because it was established by renowned English lawyer Sir Matthew Hale in 1736 in the treatise Historia Placitorum Coronae, essentially beginning the English legal principle of neglecting marital rape as a whole.
That really displays the ignorance the law had against sexual assault, especially within marriages for such a prolonged amount of time.
Hale's doctrine, written literally centuries before, still being enforced, called for numerous challenges for modern women's rights. I think it doesn't just stop at the fact that sexual intercourse without consent is unacceptable, but it also shows how the legal principles actively objectified women. What the Hale's doctrine does suggest is that, firstly, the moment women are married, apparently their sexual consent and autonomy is automatically overpowered by their husband's desires. It suggests that a woman's body is for her husband to exploit, right? Not a literal person's body, hence its literal objectification by the definition. And removing consent and the ability to consent in the first place means literal domination for one party, and according to the law at the time, women's rights are completely erased the moment they marry someone. And so the objectification here in the law, which normalized and desensitized sexual violence, meant that victims are actually never properly protected or supported to begin with because of the legal principles literally asserting this. So it meant that institutions that ought to be protecting everyone ends up being an inevitable perpetrator against victims. But one thing, importantly, marital rape was considered to be morally wrong by society at the time of this case too. It was the law that, funnily enough, was quite literally behind. It shows the importance of the law's ability to be present and adaptable in modern society so it doesn't actually feel delayed or lack a lot of support for modern day standards.
Definitely. On top of the institutions becoming perpetrators, such delayed legal principles that undermine victims and their struggles accelerated the psychological state of learned helplessness of victims who did experience marital rape. Learned helplessness is a specific application of operant conditioning, where after prolonged exposure to stressful situations and continuous failed attempts to improve their situation, the victim stops trying to change the circumstances, even when the opportunity to do so arises. People who experience continuous abuse from their partner would have tried to reach out and get help, but since there was no legal recognition of the crime, they were unable to have gotten this help, and would most likely have just accepted the situation that they were in.
So such issues that the institution called for meant that there was a need for appropriate adjustments in the law. On the 30th of July 1990, the husband appeared at the Crown Court at Leicester. Unsurprisingly, he tries to claim that a husband could not be guilty of raping his wife. But Judge Owen J. rejected this submission, stating that consent could be withdrawn in this case as they had stopped living together and terminated sexual intercourse ever since. Hence, they are clearly separated in practice. Therefore, the husband was sentenced to 3 years for attempted rape and 18 months for assault.
However, it didn't end there. The husband who disagreed with Judge Owen J.'s ruling appealed upwards to the Court of Appeal. The Court of Appeal also agreed with Judge Owen J.'s ruling, but the Court of Appeal did recognize the fact that the issue itself was very significant, as it disputed directly against a deeply rooted legal principle, and thus allowed the husband to appeal to the House of Lords.
Before we progress any further, the House of Lords is the upper house of the British Parliament that reviews laws in depth and aims to improve them. The House of Lords consists of unelected members, or the Lords, who do the act of reviewing, scrutinising and improving laws. At the time of this case, of Crown against R, the House of Lords was the highest court that finalised appeals in the UK. Note that this is no longer true because as of 2009, the highest court in the UK became the Supreme Court of the UK.
And with that in mind, the husband did appeal to the House of Lords, but in a unanimous decision, it was dismissed. It became officially acknowledged that a husband is criminally liable for raping his wife. Lord Keith Kinkle gave the leading judgment that all the law lords agreed with, in which his lordship addressed Hale's doctrine, and how much the status of women and married women have drastically changed since that era.
An important thing to remember here, though, is that this decision didn't actually change the law itself, but it's still relevant and important because it firstly finally acknowledged the fact that the concept of marital exemption is just invalid and outdated, so it really changed that legal principle that was deeply rooted beforehand. And then secondly, it abolished that specific invalid legal principle officially, right? It was leaving the precedent that the argument of it's okay because it was marital is no longer substantial. And so therefore it enables stronger protection for marital rape victims, forming more social awareness against such issues with this huge legal principle change. And it was a significant step for women's rights and feminism, especially because activist groups in the UK like Women Against Rape have been leading campaigns since the 1970s calling for the criminalisation of marital rape, and they fought for married women's autonomy and consent, so this was finally listened to by the legal system. So, it shows us how even if not literal law changes or additions are carried out, just principle changes itself can be crucial for how the law is actually executed in practice and how it actually protects our stakeholders.
Moreover, this principle change was also crucial in the sense that women were able to become conscious and more aware of the injustice that they were experiencing. Before this principle change, victims could not fully recognize that they were being violated of their rights. This can be explained through a concept known as epistemic injustice. Epistemic injustice is essentially when someone's experiences or knowledge aren't taken seriously, often because of bias or societal norms. There are two types of epistemic injustice. The first is testimonial injustice, where a person's word isn't trusted because of a social group they associate with, such as gender or race. The second one, which is more relevant to this context, is hermeneutical injustice, which is where someone can't fully comprehend or express their experience, because there are no already established concepts or language to describe what happens. Before marital rape was recognized as a legal concept, victims most likely didn't even realize or couldn't articulate their victimization, because it wasn't recognized as valid knowledge at that time. Additionally, this reflects institutionalized gaslighting, where the legal system enforced the idea that what the victim was experiencing wasn't, air quotes, wrong, which caused victims to doubt their perception and hesitate to speak out.
However, once this principle change was established and marital rape finally became a punishable concept, it validated women's experiences and helped correct this injustice. Women became more aware of their rights and their experiences were finally recognized as legitimate, allowing them to challenge and report abuse. This case really shows us the importance of clarity and adaptability in the law to ensure the rights of people in society.
Most definitely. Thank you for staying with us until the end. We hope you enjoyed. Coffee Over Court out!